cross-examination, criminal defense attorneys Ann Bremner and Sara Azari. Good to have both of you with us. We even heard from some of our own legal voices earlier this morning, some criticism on the initial cross-examination yesterday, that half an hour or so from the prosecution, that perhaps she wasn't aggressive enough. What are you hearing today, Sara, in this cross-examination? What do you think she is getting out of Travis McMichael?
Erica, she is doing a stellar job. She is actually getting out of him, one, his prior inconsistent statements. She is having him admit to the fact that Arbery was unarmed. He's talking about what we saw 12 days ago. He might have had a gun in his waistband. That doesn't count. That is not imminent threat of great bodily injury or death. And remember that to get to, the jury needs to be satisfied that there's a citizen's arrest, a valid one, before they get to the self-defense analysis. I think she's doing an amazing job at getting him to admit that Arbery did not pose a threat, that he was running away, and that this guy was really just investigating. He was not a cop. He was not deputized. He didn't have a badge. She got all of this out of him, and yet he was cornering Arbery into answering his questions about where he was going and what he was doing. He was investigating. There is no law in Georgia that allows him to do that, and there is no law that compels Arbery to stop and speak to him. I think she is doing an amazing job.
Those questions you raised there, Sara, overhang this case, right? Is that you have a private citizen here making judgments about whether Arbery was a threat. Was he armed? Had he committed a crime? Was there reasonable suspicion or probable cause? I mean, all those things being laid on that person, and that's what the prosecutor seemed to be digging down on. Ann Bremner, one moment that struck out to me just a couple moments ago, she said, the prosecutor, who is Linda Dunikowski, rather, to Travis McMichael, at this point, Arbery was pinned between the two vehicles, right? That at one of the points right before the shooting took place. How essential is that detail to you there in terms of describing, over time, the cornering, right, of Arbery?
Right, and we had testimony in this case that he was cornered like a rat. The question in this case is, are these people acting as the law? Is vigilantes acting with some kind of authority under law enforcement on this basically citizen's arrest statute that existed at the time? Are they breaking the law by killing Arbery and not acting in self-defense? Or are they above the law, which they're not? We know nobody is. So when you look at whether or not they falsely imprisoned Arbery, that's the felony for felony murder. The question is whether or not they could lawfully do that under the citizen's arrest statute. And guess what? Arbery didn't commit a felony. He didn't take anything from a building. He didn't intend to commit a crime within a building, within the meaning of the felony burglary statute. So that's their problem. I mean, it's kind of a house of cards, a fallacy that they're trying to say, we were justified, legally we were acting as the law, and then therefore when we pinned him, we were trying to hold him legally, and then when we used force, we were in a place we had a right to be, and we didn't provoke a use of force unlawfully. We were doing the right thing, therefore we acted in self-defense. The state has to disprove that beyond a reasonable doubt, and there should be a defense verdict.
Just to pick up, too, on something that you touched on earlier, Sara, one of the things that the prosecutor was noting, she repeats, so 3 times Ahmaud Arbery demonstrated he didn't want to talk, that he wasn't threatening in any way, verbally or physically. He agrees, Travis McMichael agrees, he didn't want to talk. She was asking him at the time about, whether he felt threatened, and he said, no, there was no reason for it. And also talked about his gun falling out of his truck. He put it back because he felt there was no reason for it at the time, that the gun had just sort of fallen while he was driving, and he didn't want to pick it up while he was driving because that wouldn't be safe. Those specific moments, how is that laying the groundwork for, if this is obviously what she wants to do, dismantling that claim of self-defense and how Travis McMichael was feeling in those moments?
Done and done, Erica, right? Because if he didn't feel a threat, if he didn't believe that Arbery had a gun, if he was running away and just didn't even want to talk to him, how is he a threat? How is that an imminent threat of great bodily injury or death to justify self-defense? And also, to Ann's point, you have to have that felony burglary. And to the criticism that was expressed about the DA yesterday, no, I think she did a great job yesterday, too, because she presented video evidence of Arbery being at this unoccupied home under construction, but that he never broke in, which is an element of burglary, and that he never committed a felony. He didn't steal anything. He didn't do anything while he was on this premises. It's unclear why he was going there. It's undisputed that he was going there, but there is no underlying felony to justify a citizen's arrest. So like Ann said, these guys are they taking it upon themselves, maybe because he was a Coast Guard back in the day, that, you know, he gets to investigate. He gets to pin down people to speak to him because he's fishing around to see what's going on in the neighborhood. That is not justification, and this is not self-defense.
And as folks watch this, there are the things that seem right or acceptable to people. Then there's the law, as it was in Georgia at the time. And there was at the time, though it's since been repealed or largely repealed, a law that allows for citizens' arrest. From a legal standpoint, how does that change the standard for a private citizen determining probable cause, but also a private citizen making a reasonable judgment about self-defense? Does it change it, and how significantly, in your view?
Well, basically, and it's the underpinning of the defense is basically saying we were acting lawfully, but the problem is there has to be a reasonable and probable basis that there was a felony committed, or that they saw it, that it was committed in their presence, for them to make a citizen's arrest. That gives them the justification, basically, to say this is not false imprisonment. We didn't commit felony murder in the course of a felony false imprisonment. So they're trying to get rid of that charge. But then when they get to the situation of pinning Arbery and then being involved with having a weapon that they say he grabbed, they can't do that unless they were acting lawfully. And on these facts, it's apparent that they weren't. And the prosecutor is doing a nice job. You know, one thing with cross-examination, you want to be brief, be brilliant, be seated. I think she needs to wrap it up because I think she's done well with him, and his story, at least, I think at this point, is not credible.
Yeah, oftentimes as you watch these things, if you don't often watch them, it can seem very methodical, right? But you do see that each of the points the prosecutor was trying to tick off there. Of course, the question is how the jury receives it. Ann Bremner, Sara Azari, thanks so much for joining us this morning.
Thanks.
Thank you.